When you're filing for divorce in Idaho and you have children, there are two critical sections in your divorce petition that can make or break your case. Today, we're going to break down paragraphs 4 and 5 of the Idaho petition for divorce, the sections that identify your children and establish whether Idaho courts can legally make custody decisions. Getting these things wrong could invalidate your entire custody order. Let's make sure that doesn't happen. First up, paragraph 4. This is where you list every minor child from your marriage. Here's the critical part that trips people up. The rules require that the full legal name of each child get listed. Not the nicknames, not the initials, the complete name as it appears on the birth certificate. Why does this matter? Because every court document from here on out must use these exact names. Get it wrong now, and you'll face delays, rejections, and enforcement problems later on. Now for paragraph 5. Now this is all about the UCCJEA. Now don't let the acronym scare you. This law simply determines which state can legally make custody decisions. Think of it this way. If you've moved between states, live with relatives, or your ex lives in another state, the court needs to know Idaho is the right place to decide custody. The UCCJEA prevents different states from issuing conflicting custody orders. Paragraph 5 has 4 different parts, and you have to answer all of them. First, list everywhere the children have lived for the past 5 years. We need the addresses, the people that they lived with, and the dates. Yes, even the summer with the grandma counts. Second, disclose any court case involving your children where you were a party or a witness. This includes custody cases, child support, protection orders, everything. Third, any other cases you know about that could affect your children, even if you weren't involved. Child protection proceedings, guardianships, criminal cases affecting parental rights, everything. Finally, you have to list anyone besides you or the other parent who claims visitation or parenting rights. This includes a grandparent with a court order visitation, a court-appointed guardian, anybody that has visitation rights or will claim them. You have to list them all. And here's the golden rule. As long as the children have lived in Idaho for the past 6 months, 6 consecutive months, the courts in Idaho can make those custody decisions. Now, if it's a baby under 6 months, it's since birth. But the 6-month rule is what you're looking for. This isn't arbitrary. It ensures the court has access to teachers, doctors, and anybody else who knows your child's life and can testify about their best interests. Now take the time to get this right the first time. Your future self and your children will thank you.